Hi guys, and welcome to another episode of Attorney Ja Vlogger. We'll take up part 5 on the law of negotiable instruments today, and we'll be talking about the rules on holders. No? We'll talk about the rights of holders in due course as well as holders who are not in due course. So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Okay? So, a holder is simply a payee or an endorsee of a negotiable instrument who is in possession of said instrument, or the bearer of a negotiable instrument who is entitled to receive the sum for which the instrument calls. Okay? Now, we have different kinds of holders, and the first one is a holder in due course, who is simply one who has taken the negotiable instrument under the conditions specified in Section 52 of the Negotiable Instruments Law. It will be better for you if you memorize this, no? Okay? So, Section 52. And the holder in due course, he holds the instrument free from personal defenses available to prior parties amongst themselves. Meaning the personal defenses will not work against the holder in due course. However, real defenses may be invoked against a holder in due course. Okay? Next, we have a simple holder or a holder who is not in due course. Okay? He is simply someone who becomes a holder without any, some, or all of the requisites specified under Section 52 of the Negotiable Instruments Law. So, the effect of this is that the holder who is not in due course, he holds the instrument subject to the same defenses as if the instrument were non-negotiable. In other words, it's just like an assignment, and the transferee will simply be an assignee. Okay? However, so he is subject to both real and personal defenses. However, the holder not in due course may still enforce the instrument and receive payment. Okay? And finally, we have the holder for value. And he's simply someone who has received value, or has given value rather, no? Someone who has given value for the negotiable instrument. Okay, so the law says where value has at any time been given for the negotiable instrument, the person who gave that value is presumed to be a holder for value with respect to all who became parties prior to the time when value was given, no? Until, of course, the contrary is proven, since this is a disputable presumption. Okay? So why do we have classifications, no? Because each class has certain defenses which are available to its own class, no? And cannot be available to the other class. Okay? But if there are no defenses that are available, then there is no distinction among the holders. Doesn't matter anymore. Okay, so the distinction is important for the purposes of defenses. And we'll take that up in the next video. Okay? So let's talk about the rights of the holders in general, meaning rights which will apply to all of the holders, no? Holder in due course, not in due course, and holder for value. First, of course, under Section 51 is that any holder can sue on the negotiable instrument in his own name. Okay, he may enforce the negotiable instrument in his own name. And second, he is entitled to receive payment on the instrument. And if payment is done in due course, meaning that payment was made at or after maturity to the holder in good faith and without notice that his title is defective, then the instrument will be discharged. Okay? Now we have two other rights, no, which are contained in Section 13, although the bulk of Section 13 is better discussed on the defenses, no, in the next video. Okay? But please take note, and under Section 13 there are two instances contemplated. First, let's say the instrument is expressed to be payable at a fixed period after date. Okay? It's like please pay X or order 30 days after June 10, no? Like that. Okay? So, in that case, if the instrument is issued undated, okay? Okay, that is the first case. Second case, if the acceptance by the drawee is where the acceptance is payable at a fixed period after sight. like pay the instrument 30 days after sight or 30 days after the drawee sees this, no? Okay? So in those two cases, issued undated or acceptance after sight is undated, no? Any holder has the right to insert the true date of either issue or acceptance, and then the instrument will be payable accordingly. Okay, that's the right to insert the date. Okay, now you recall in my previous videos that the omission of the date in the issuance, no, when making it, okay, does not affect negotiability. So an instrument may be issued undated except where the date is necessary to determine the time of maturity. In other words, if the body says pay 30 days after date and the instrument is not dated, then we do not know when that will be due, when it is payable, okay? So this is where Section 13 applies, okay? So it contemplates a situation where the date is necessary to fix or determine the maturity date. And the remedy, as I said earlier, is simply to insert the true date. And in case of acceptance, the date that should be placed there is the date when it was presented for acceptance, not when it was actually accepted. Okay? Now, what if the party inserting the date is a bad person, no? So the law says that the insertion of a wrong date does not avoid the instrument in the hands of a subsequent holder in due course. He has to be a holder in due course. So the instrument will not be void. The instrument is not affected by the wrong date if it's in the hands of a holder in due course. And as to that holder in due course, the date that is inserted will be regarded as the true date. Okay? Because the insertion of a date is considered a material alteration under Section 125. So you check that out, no? If you can, memorize it as well, no? And under the material alterations, anything that changes the date, the sum payable, the time or place for payment, number or relations of parties, the medium or the currency of payment, in case a place of payment is added which was not contemplated before, or any other which alters the effects of the instrument would be a material alteration. Okay? Another right of the holder in general would appear in Section 14 on incomplete but delivered instrument. Okay? Again, we'll talk about this under the topic of defenses more, but just for the sake of the rights of the holders, no, Section 14 says that where the instrument is wanting in any material particular. What is a material particular? It's any particular which is proper to be inserted in the instrument to make it complete, including the name of the drawer. Okay? So if the instrument is wanting, meaning kulang ng material particular, the person in possession of it, no, meaning the holder, has a prima facie, no, it's a disputable presumption, a prima facie authority to complete it by filling in the blanks, no? As I said, may kulang, he can fill in the blanks, but this is just an authority, a prima facie authority, meaning it can be disputed, no? Okay, but this authority does not include this authority to fill in the blanks does not include an authority to alter. Okay, you can fill in, but you cannot alter, meaning you cannot change the amount, you cannot insert words like to order or to better if that was not the original intention. Okay, and the second part of this Section 14, no, is that in case of a signature on a blank piece of paper, no, okay, which is delivered by the person who made that signature with the intention to convert that paper into a negotiable instrument, it operates as a prima facie authority to fill it up for any amount. Okay? Parang yung mga blank check, if you've seen movies like that, blank check, no? It's like that. Not that exactly, because that's a check, no? So, a signature, again, on a blank piece of paper delivered by the person who made that, okay, with the intention to convert that paper into a negotiable instrument, it operates as a prima facie authority to fill it up for any amount. Okay? Here, you have to show that there is a purpose to convert the blank paper to a negotiable instrument, that it was filled up strictly in accordance with the authority given, and that it was done within a reasonable time. Okay? So now let's talk about a holder in due course. We already defined who he is. But as I mentioned, no, it is better for you to memorize section 52 because that is how we will know if a holder is a holder in due course. He is one who has taken the instrument under these conditions. First, that the instrument is complete and regular on its face. Complete and regular, okay, on its face. 2, that he became the holder of the instrument before it was overdue, okay, and without notice that it had been previously dishonored if such was the fact. Number 3, that he took it for good faith and for value. He took it in good faith and for value. Okay, and 4th, that at the time it was negotiated to him, he had no notice of any infirmity in the instrument or any defect in the title of the person negotiating it to him. Okay, so all 4 of those must concur. Can the payee be a holder in due course? Yes. Okay, because he's included in the definition of who a holder is, no? The payee or endorsee who is in possession or the bearer thereof, no? So, the payee may have received it from another holder, or the payee may not have dealt directly with the maker or the drawer, so which is why he may have received it. But can a drawee be a holder in due course? No, he cannot. Okay? Because in order for a person to be a holder, no, he must take it he must take the instrument, no, in the course of negotiation towards the drawee. Okay? So he can never be holder in due course. Okay, so let's talk about the requisites one by one, no? Complete on its face. This is simple, no? It is incomplete if it is wanting in any material particular, no? Which I discussed no earlier, date, sum payable, etc. That's material alteration, sorry. Any material particular, anything which is supposed to be on the instrument, no? Okay, so it is incomplete if it is wanting in any material particular, you know, except for the allowable omissions under the law, like date, consideration, place where it is drawn, or place where it is payable, no? Those are allowable omissions, meaning the instrument will still be negotiable if those are not there. I discussed this already in a previous video, okay? And when a person takes an incomplete negotiable instrument, he is put on inquiry. He has a duty to inquire why it is incomplete. If he fails to make an inquiry, then he is in bad faith and he takes that instrument subject to all the defenses, personal and real. Okay? Now, regular on its face. Okay? An instrument is irregular if the alteration, no, which I mentioned earlier, no, if the alteration is visible or apparent on its face. Okay? If not apparent, then Section 124 will govern and the instrument will be void. Okay? Third, the instrument must be taken before it is overdue. Okay? Or he became holder of the instrument before it was overdue. When we say overdue, okay, it should be after the date of maturity, not at maturity. On the exact date of the due date or the maturity date, that's still not yet overdue. Okay? It's overdue 1 day after. Okay? And if the instrument is overdue, it carries with it the presumption that it was dishonored. Okay? So, again, there is a duty now on the part of the holder to inquire why the negotiable instrument is still in circulation. Okay? Why is this still being negotiated? Lagpas due date na. Okay? But take note that an overdue negotiable instrument can still be negotiated. The only effect is the holder of that overdue instrument will now be a holder not in due course. He cannot get the rights of a holder in due course. Okay, and take note, under Section 53, where an instrument is payable on demand, is negotiated for an unreasonable length of time after its issue, then the holder is deemed, he's presumed, he's not deemed, okay, he's presumed to be a holder not in due course, okay? He's not a holder in due course. He's a holder not in due course, okay? Now, next requisite, no? Next condition under Section 52. He must have become a holder without notice of dishonor. This is simple enough, no? No notice of honor was given to him, okay? And dishonor, whether it be by non-acceptance or non-payment, okay? A dishonored negotiable instrument may still be negotiated further, but he is a holder not in due course. He doesn't have the rights of a holder in due course. Okay? Now, the holder must have also taken it in good faith to be a holder in due course. And of course, following the law, good faith is presumed. But this presumption of good faith is destroyed if the payee or endorsee acquired possession of the instrument under circumstances that should have made him inquire to the defective title, no, of the person who negotiated the instrument to him. The burden is now on him to prove that he acquired it in good faith. Okay? So the holder must also have taken the instrument for value. And the value is any consideration sufficient to support a simple contract. And the rule is every negotiable instrument is presumed, no, prima facie, presumed to be issued for a valuable consideration. And every person whose signature appears on the instrument, okay, is presumed to have become a party to said instrument for value. Okay? Now, when we talk about consideration for making the instrument, okay, consideration does not affect negotiability. So the question of consideration, no, is only important to determine whether the holder is a holder in due course or a holder not in due course. Okay? Next, and the final requisite, no? At the time of negotiation, he had no notice of the infirmity on the instrument or defect in the title of the person negotiating to him. Okay? So, when we say infirmity, no? These are things which are wrong but are not absent from the instrument. Okay? There's something wrong with a certain thing in the instrument. So, we can find this in sections 13, 14, 15, 16, 21 with signature by procuration, no, and 23 on forgery. Okay? And we can say title is defective as in section 25, no, in two cases. First, in the acquisition of the instrument. Okay? In case the instrument is acquired or any signature on the instrument is acquired by fraud, okay? Fraud, force, duress, fear, for any illegal consideration, and any other unlawful means. Okay? So, if the instrument or any signature was acquired by any of those means, okay, then there is a defective title. Now, a title can also be defective in negotiation. And this happens in case of negotiation in breach of faith, which simply means, an example na lang, no? Negotiation after having received payment. If you receive payment on the note, why will you negotiate it? Remember that full payment on the instrument discharges the instrument and destroys its negotiable character. So you cannot negotiate it further. If you do so, there is a breach of faith. Okay? So there is a defect in title in that case. Or under circumstances that amount to fraud. Okay? Now, when it comes to the infirmity or defect, it must be actual knowledge. Okay? In order for it to amount to bad faith. The bad faith does not contemplate mere negligence or failure to make inquiries. Why? Because the law does not impose an obligation on the holder, okay, to make an inquiry before acquiring the negotiable instrument. Because that will defeat the purpose of facilitating transactions. It will unduly hamper it, no? If every holder would have to ask, oh, is there an infirmity? Oh, is there an infirmity? Okay? However, no, if there is actual knowledge of suspicious circumstances, no, it is you can see right away, or there are circumstances that should put you on guard, okay, or that would compel a reasonable man to investigate, okay, and then that person willfully refrains from making inquiries or intentionally ignores the infirmity of defect, then that is bad faith now, okay. There is a duty to inquire, and then he willfully or intentionally does not inquire, then that is bad faith. But the mere failure or negligence to ask, okay, that's not bad faith. Okay, I hope you see the distinction. Okay? Okay, so let's move on now. Now, what is the effect if there is notice of the defect? Simple, no? It destroys the status of being a holder in due course, and now that holder is subject to all defenses, whether personal or real. Again, I'll talk about that in the next episode, okay? And please take note of section 54, which simply says that where the transferee receives notice of any infirmity in the instrument or defect in the title of the person negotiating the instrument before he has paid the full amount agreed to be paid for said instrument, he is deemed a holder in due course only to the extent of the amount paid for by him, no? In other words, he's buying the instrument, no? And sige, let's say if the holder takes the instrument, no, but he has not yet paid for it, no, and he receives notice, no, that there's an infirmity, okay, does he have to pay pa for it? No, he's relieved now from the obligation of having to pay for that instrument, okay? What if he has already paid part, no, or he has paid partially the sum due on for the purchase of the instrument, no? Then he does not have to pay the balance, okay? And he will now be a holder in due course to the extent of which he paid. If the note is 1,000 and the is worth 1,000, no? The sale of the instrument is worth 1,000, no? And he has paid 800, he is no longer, and then he receives notice of the infirmity, he should not pay anymore the remaining 200, but he can now be a holder in due course with respect to the 800, okay? Now, the law gives us a presumption, no, on who can be deemed a holder in due course. This is in section 59, no? And it simply says that every holder is deemed prima facie to be a holder in due course, okay? And this only will apply to those holders under 191, no, the payee or endorsee who is in possession or the bearer of the instrument, okay? Every holder is deemed prima facie to be a holder in due course, okay? In other words, once a person is able to show that he is a holder, the presumption accrues. It applies to him already. He is now presumed to be a holder in due course, okay? He does not have to prove compliance with section 52 anymore, okay? However, take note, when it is shown that the title of any person who has negotiated the instrument was defective, no? Like it was not payable to order or to bearer, no? It was not payable to him or to bearer, no? Then the burden is on the holder now, okay? To prove that he is a holder in due course. Why? Because the person from whom he gained the instrument, okay, had defective title. So now he has to prove that he obtained the instrument complying with the conditions under section 52, okay? And he will now be a holder, okay? Wait, he has to prove that he is a holder in due course, or, no, there's one more pala, no? He has, or that some person other than him, through whom he claims, has acquired the title as a holder in due course, okay? Again, when it is shown that the title of any person who has negotiated the instrument was defective, okay, any prior party, no, who is an endorser, no, any previous endorser who has negotiated the instrument, if the title of that person was defective, like it was not payable to that person, okay, or to that person or to bearer, then the burden now is on me, the holder, okay, to prove that I am truly a holder in due course under section 52, or that I am claiming title from someone who has acquired the instrument as a holder in due course, okay? And now I will be known as a holder through a holder in due course, okay? So that's the rule, no? There is an exception, okay? If the holder has the holder will have no burden to prove that he is a holder in due course in case there is a party who has bound himself on the instrument before the acquisition of the defective title, okay? Now, the law also gives us the presumption of delivery. This is also in section 16, which I mentioned earlier, and we'll be discussing in the next episode, no? When the negotiable instrument is in the hands of a holder in due course, okay, a valid delivery of that instrument by all parties prior to him so as to make them liable to the holder is conclusively presumed, okay? Take note, conclusive, okay? So you cannot prove it otherwise. Again, if the instrument is in the hands of a holder in due course, a valid delivery thereof, no, of the instrument by all parties prior to the holder, okay, so as to make them liable to me, the holder is conclusively presumed. Okay? Now, there's also a presumption as to when the holder is when the holder is a holder not in due course. And I mentioned this earlier. This is under Section 53, no? So, where an instrument is payable on demand, is negotiated for an unreasonable length of time after its issue, the holder is deemed to be a holder not in due course. He's not a holder in due course. Okay? So, this applies to instruments which are payable on demand. Okay? And how do we determine what's a reasonable time? We take into account the nature of the instrument, the usage of trade or business, and the facts of the particular case. So what are the rights of a holder in due course? First, of course, he may sue in his own name. Okay, he may sue on the instrument in his own name. Second, he may receive payment, and if the payment is in due course, then the instrument will now be discharged. Third, he will now receive the instrument free from all defenses of prior parties. Okay, so real or personal, personal. He takes it free from personal defenses amongst prior parties. He is still subject to real defenses. And fourth, he can now enforce payment for the full amount against all parties liable, except in the following instances, which I will be discussing. First, take note of Section 27. A holder who receives a negotiable instrument as a security for a principal obligation, to make sure that principal obligation is performed, has a lien, or a claim over the negotiable instrument, and he is a holder for value to the extent of that lien. So the rules are as follows in that case. If the amount of the instrument is more than the debt, then he can collect the full value of the instrument and apply the proceeds to the payment of the debt. But the surplus, he has to give it back to the debtor. This is consistent with the new law, the Personal Property Security Act. Okay? I have a series on that. You can watch that. It expressly repealed the provisions of pledge and chattel mortgage. Okay? Now, what if the amount of the instrument is less than or the same as the debt which is secured? Okay? Then the holder is a holder for value for the full amount. Okay, and he may recover said full amount. Now, when it comes to personal defenses, if there are personal defenses available, then the holder can only collect on the instrument only up to the amount of the debt. But if there are real defenses, he can recover nothing. Okay? Second exception, is under Section 54, which I discussed earlier. Okay, when the holder acquires notice of an infirmity or defect before he has paid the full amount, he is deemed to be a holder in due course only to the extent of the amount which he has paid. Okay, and finally, in case of any alteration under Section 124, the holder in due course can enforce payment only according to the original tenor. Okay, before the alteration, according to the original tenor of the instrument. Okay, now let's go to a holder not in due course. Okay, a holder not in due course is subject to the same defenses as if the instrument were non-negotiable. He's subject to real and personal defenses. Okay, except, now this is very, very, very important. Except, the exception is the shelter rule, which is Section 58, second sentence of Section 58. In other words, a holder who derives his title through a holder in due course, okay, and who is not a party to the fraud or illegality affecting the instrument, has all the rights of a holder in due course with respect to all parties prior to the person who negotiated it to him. Okay? Now, the purpose of this is to prevent the substantial reduction of the rights of the innocent holder in due course. Okay? Because his market to transfer the instrument will now be limited to those who have no notice of original infirmity. So, the shelter rule seeks to avoid that. Okay? So, since the innocent holder in due course can collect from the party primarily liable, whether it be the maker or the drawee, since he can collect from them, it makes no difference to the party primarily liable into whose hands the instrument may pass. Okay? But it is very important, please take note that to enjoy the rights of a holder in due course, he must derive title through the holder in due course, and he is not party to the fraud or illegality affecting the instrument. Okay? Now, this is also important. There's an instance when the shelter rule will not apply. Okay? And the shelter rule will not apply, no? In other words, the holder, even if he has notice of the infirmity, will not acquire the rights of the holder in due course if the holder was a previous holder not in due course. Okay? He was already not a holder in due course before, no? And then he subsequently reacquires it, the instrument, no? The shelter rule will not apply in that case. Okay, whether he acquires it through an agent or personally, he will not acquire the rights of a holder in due course if he was previously a holder not in due course. In other words, he cannot improve his situation by simply reacquiring the instrument. Okay? There is no loophole there. Okay? He cannot, once a holder not in due course, he cannot improve his situation. Okay, so let's give an example, no? So, you can understand better, no? So let's say Goku induced by fraud induced Frieza, no, to issue a promissory note, no, which was then endorsed to Vegeta. Okay, Frieza endorsed the promissory note to Vegeta. Okay, Frieza was able to obtain the promissory note from Goku through fraud, and therefore Frieza is a party to the fraud since he was the one who endorsed Goku. Okay? Now, when Frieza endorsed the promissory note to Vegeta, Vegeta was not a party to the fraud, but he knew of it. So he has notice of the fraud. Okay? Now, Vegeta endorses the note to Gohan. Okay? Gohan is a holder in due course because he's not party to the fraud and he did not know that the fraud occurred. Okay? Now, let's say Gohan, who is the holder in due course, endorses it to Trunks. Okay? Gohan endorses it to Trunks. But Trunks, while he's not a party to the fraud, Trunks knew that the fraud happened. Okay? So, he took the instrument with notice of the fraud. Okay? So, that's the facts for now. Okay? So, let's say, what is the situation, what is the status now of Trunks? Trunks is a holder not in due course. Why? Because even if he's not a party to the fraud, no, he did not cause the fraud, he has notice of that fraud took place. So, he's a holder not in due course. Okay? But, even though he is not a holder in due course, take note, from whom did he get his title? He got it from Gohan. And Gohan is a holder in due course. By virtue of the shelter rule, which I discussed earlier, Trunks, even though he's a holder not in due course, has the rights now of a holder in due course. In other words, he is now protected from personal defenses. Okay? He is now protected from personal defenses. Okay, so the defense of fraud, simple fraud, cannot be used against Trunks, and Trunks can now enforce the instrument. Okay? Now, what if instead of endorsing the instrument to Trunks, no, Gohan, okay, endorses the instrument to Frieza? Can Frieza recover on the note? No. Okay? Why? Siya may gawa ng fraud. Ano ba? Okay? So since he is a party of to the fraud, he is not allowed to enforce the instrument or receive payment on the instrument. Okay? But what if now Trunks endorses the instrument to Cell? Okay? And Cell has notice of the fraud but is not a party to the fraud. So Cell is now a holder not in due course. Okay? He's a holder not in due course. Can Cell now recover or enforce payment on the instrument? Okay, no. Why? The protection of the shelter rule only works between immediate parties. So the holder in due course ni Gohan is only passed on to Trunks. And the real status of Trunks, no, even though he gets the rights of a holder in due course, Trunks is still really a holder not in due course. And his status of being a holder not in due course will still remain. No, he cannot pass the status of Gohan onto Cell. And Cell himself is a holder not in due course. He knew of the fraud, even though he did not participate in it. And since he is a holder not in due fraud, since he is a holder not in due course, then he is subject to the personal defense of fraud. He cannot claim payment, no? Because the personal defense of simple fraud can be used by Goku against Cell. Okay? But what if, instead of Cell being holder not in due course, he is actually a holder in due course pala. Okay? So let's say now he's a holder in due course. And then, since he is a holder in due course now, he endorses the instrument back, all the way back to Vegeta. If you remember my facts, Vegeta is a holder not in due course. Why? Because even if he did not participate in the fraud, he has notice of the fraud. Can Vegeta now be a holder in due course through the holder in due course of Cell? Okay? Can he gain the rights of Cell through the shelter rule? No, because remember, as I discussed earlier, a person who is a holder not in due course cannot improve his situation by using the shelter rule. Okay, that is the exception to the shelter rule. He is returned to his prior position, and he is now holder not in due course again. Okay, so that's the illustration of the shelter rule and its exception. Okay, so finally, let's just talk up quickly about the rights of a holder not in due course. Of course, he can sue on the instrument on his own name, subject, of course, to personal defenses, no? Both personal and real defenses, which may be used against him to prevent him getting paid, no? And he may receive payment if it's in due course, then it discharges the instrument. Again, subject to the personal and real defenses. Okay? So in other words, the third right is that he holds the instrument subject to the same defenses as if it were non-negotiable, meaning both personal and real defenses may be used against him. And finally, if he derives his title through a holder in due course and he is not a party to the fraud or illegality, then he gains the rights of a holder in due course against all prior parties, which is known as the shelter rule. Okay, so please just take note. Okay, so please wait for my next video on defenses, no? And I hope you may have picked up a thing or two. See you soon, guys. Okay, bye.